This is a special report from True Crime Today and the Hidden Killers podcast.
All right, good morning. Good morning, Mr. Peterson. Can you both see and hear the proceedings, sir?
Yes, Your Honor, I can. Thank you.
All right, and do we have your consent to proceed via Zoom this morning?
Absolutely. Thank you, Your Honor.
All right, thank you. So the record should reflect Mr. Peterson has consented to appearing via Zoom. He is appearing electronically from Mule Creek State Prison. Okay, the court had requested counsel to be present this morning for a status conference. There are 3 motions pending before the court. Motion for post-conviction discovery under Penal Code Section 1054.9, a motion for post-conviction DNA testing, and a motion to seal court pleadings that have been filed in relation to those 2 motions. Because we had not yet had a hearing date set, the people's response had not yet been due, so I wanted to discuss with counsel a briefing schedule and scheduling a substantive hearing on those 3 motions. I also wanted to, there were references in the pleadings to potential meet and confer process between the parties to see if they had had any luck in narrowing the issues that the court may have to decide in terms of discovery and testing. So I wanted to check in with counsel, see where we are with that process, and then we'll move forward from there. So let me start with the moving party. Counsel for Mr. Peterson.
Yes, Your Honor. We did go to the district attorney's office in Stanislaus County on February 13th to have a meet and confer. Unfortunately, we were unable to resolve any issues. I do have a letter memorializing the discussions that were had. If the court would like a copy, I'd be happy to provide that. I sent it to the district attorney's office on February 24th, just setting forth the issues we discussed and the impasses that we had.
Okay, thank you. Counsel for the people.
Your Honor, we did have a meet and confer, and we are at the position where we intend to file our motion, our responsive motion. And what we need the court's help with perhaps is identifying the date that we begin to run that time. We have 90 days for service.
Hold on just a second, Ms. Slaughter. We're getting a little bit of background. I'm going to mute, or I'm going to ask the clerk to mute Mule Creek because we are getting some background noise. So, Mr. Peterson, if you do need to communicate with your counsel at any point, you can let us know that by simply raising your hand so that we can unmute you. Okay, thank you. Go ahead, Ms. Slaughter.
Thank you. So, we received the motion with all the attachments on January 9th. The AG's office, which also needed to be served, received the motion with the attachments, exhibits, on January 23rd. So we will be ready to file our response by 90 days from either of those dates. We're looking at either April 22nd from when the AG was served or April 18th from when we were served.
Okay. And so if that's going to be when you're going to be filing your responses or when you're going to be ready to file your responses, how much time would Mr. Peterson's counsel need to then file any replies?
Your Honor, we would ask for 2 weeks.
Okay.
Can I just inquire, we were given somewhat mixed signals at the meet and confer concerning whether the district attorney's office intends to file a blanket opposition to both motions or whether there are some specific items that they will be objecting to and others that they will not with respect to the discovery motion. So if the court could inquire whether they intend to file a blanket motion opposing all requests or if it's with respect to certain items, perhaps we could begin receiving the items that they are not objecting to.
I mean, I would expect that that counsel could handle that in the meet and confer process. So the people are entitled to an opportunity to respond. They can decide what the scope of their response is going to be. If you're going to need 2 weeks to respond to that, then I will set a hearing that contemplates that you will have time to file a reply and I will have time to read all of the pleadings before we have the hearing. So let's see. If the people are looking at being ready to file their responsive pleadings by the 22nd of April and counsel's going to need at least 2 weeks for the reply, then that would put us with a briefing finishing somewhere around May 6th. So we would be looking at a hearing. I'd like at least 2 weeks to review the last of the pleadings, so somewhere on or after the 20th of May.
Your Honor, if I might,
yes.
In terms of the timing of our response, I was speaking specifically about the DNA motion. That we'll be ready to respond to that on that date.
Okay.
And then we would ask for an opportunity to file a response to the discovery motion as well, and we would ask 90 days from the date we file the DNA motion to to respond to the discovery motion.
Is there a reason that you need an additional 90 days beyond for the discovery motion, or why they can't go in parallel, Ms. Vladecker?
Yes,
Or Mr. Harris?
Yes. As the court may have already seen in the pleadings, the defense pleadings in this particular case, specifically for the DNA motion, is 142 pages of pleadings, plus over 880 pages of exhibits that are attached. The exhibits came to us later than the initial pleadings, and so that's been one of the delays for us, having to go through each of those particular exhibits. The statute for the DNA motion does have a 90-day deadline. The statute for the discovery does not have a deadline. It's been interpreted by the court to be a reasonable time frame.
Okay.
We think that the DNA motion would also assist, having that resolved would also assist in some aspects as to the discovery motion, because specifically in the statute it says that the two do not work necessarily in conjunction.
Right.
Also, the discovery motion itself is another 62 pages with a large volume of exhibits for that as well. So we've been concentrating on trying to get the DNA motion, which does have the deadline, done. A lot of the materials that we will have in the DNA response will be applicable to the discovery, but we just think a reasonable time period based on the size of these motions, it's not unreasonable to ask for another period of time.
Well, I guess the concern that I have about 90 plus 90 in terms of your responsive pleadings is that the Court of Appeal has issued a stay for a relatively limited period of time. We're working on a 6-month deadline before, and I understand that there is the potential for an extension of that deadline if there's additional good cause, and not being done with the pleadings here and with the hearings here determining the scope of the discovery would potentially be good cause. But given that they have sort of given us a 6-month time window to work with for what they think would be an initial opening, I'm concerned that setting a briefing schedule for that exhausts the entirety of that time period is not going to be viewed as potentially reasonable by them. So, and these two statutes, while I understand that a lot of the issues may be interconnected with the discovery the defense is seeking, I don't see a lot of what they're seeking in the 1054.9 motion appears to me to be in the nature of file reconstruction. Some of it, not so much, but there are things where essentially they're asking for missing bait stamp numbers and other things that are referenced in reports that they already have. I don't understand why that couldn't be worked on in parallel. That's what I'm still waiting to hear. So if the people want to address that, I'd be happy to hear any argument on it.
Yes, Your Honor. One of the things as it relates to the discovery motion, there was a couple of issues. One is we believe it to be issue preclusion, where in fact there has already been a previous 1054.9 motion that has been brought, has been litigated, and resolved primarily against the defense back in 2011, 2012. So because of that, we have to go back and we have to cull out what has previously been dealt with, and that's requiring us, again, to go back through things that are not necessarily in their materials, but it's in the court record. We also believe that a lot of these items have been raised and litigated as part of the initial appeal and also litigated as part of the first habeas. So because of that, and unfortunately we will be providing to the court or asking the court to take judicial notice of the petition that was there because a lot of these issues have been raised and have been adjudicated. So because of that, there's a lot of back and forth from the record, and there is going to be a large amount of reading for both sides.
Okay. That brings up another point. The defense did make a request in the initial round of pleadings for the court to take judicial notice of the entirety of the trial court file, the entirety of the direct appeal, the entirety of the habeas proceedings, and all of the Supreme Court proceedings, including all the pleadings. Is there any objection to that request from the people?
There is as to some portions. We have a portion of it in our response to the DNA motion to address that. But
okay.
Basically for the court, anything that is part of the record of the case that has been adjudicated, we have no objections to that being taken judicial notice of because it's the law of the case in a sense. What we do have a complaint about is there's a request from the petitioners that the court take judicial notice of their pleadings in these new proceedings. Those are hearsay, and just because they've been filed does not make them admissible. So because of that, we will be objecting to those portions of their request, but the fact that there is a new petition and the previous court proceedings, those we don't have any objection to for judicial notice.
Okay. The reason I inquired was because since you had referenced that there were other parts of the file that you were going to be asking the court to take judicial notice of, I thought we might be able to get at least some of that out of the way. But if it's going to be covered in your responsive pleadings, I will wait to rule on any request for judicial notice until I see what the scope of the dispute is. All right. So let me hear from the defense on the proposed briefing timing and timing of potential new hearings.
Yes, Your Honor. We provided a very, very detailed informal request for discovery on November 14th, 4 months ago. So the district attorney's office has known for 4 months which specific items of discovery we are requesting. We gave them references to Bates pages. We gave them references to where in the police reports the items we're requesting are referred to. We were very, very specific. We spent a lot of time trying to suss out what, frankly, are very alarming deficiencies in the discovery that was provided to the defense at the time of trial. Those are the items we're requesting. I agree it should not take 180 days for them to locate those items and provide them to us. The defense was entitled to those at the time of trial. Mr. Peterson has been waiting 20 years to find some of these police reports and audio recordings and video recordings that should have been provided. So I don't think that the nature of the requests, it's not a fishing expedition. They're very precise, they're very specific, and we believe that they are probably very easily accessible. So we would ask that they begin providing the discovery that we are entitled to under 1054.9. The prior 1054.9 that Mr. Harris referenced does not include what we are asking for. It related specifically, almost exclusively, to expert materials and other evidence that is not included in our motion. So we are eager to get our investigation underway and completed. The Court of Appeal did give us a very short time period within which to conduct our investigation. The materials we are asking for are reasonable. They're within the scope of 1054.9, and we would like to begin receiving that discovery as soon as possible.
Okay. So in terms of briefing schedule, the court is prepared to accept the proposal by the district attorney as far as the DNA testing motion is going. And so the response for the responsive pleadings on the DNA motion will be due no later than close of business, filed and served by April 22nd. Given the timetable that was contemplated by the Court of Appeal and the fact that essentially the discovery request was made prior to this motion being filed and prior to the Court of Appeal issuing their stay on the proceedings to allow these issues to be litigated in the trial court, I am inclined to agree with the defense that a request for an additional 90 days beyond the briefing on the 1054 issues is too long, given the timetable that the Court of Appeal has given us. In terms of the briefing for the 1054.9, because the requests are extensive, it's a 62-page discovery letter with a number of subparts. Some of it is specifically identified by missing Bates stamp numbers, but some of it is broader than that. So the court is inclined to go about 30 days beyond the briefing deadline on the DNA motion. And so if I'm looking at roughly the end of May for the 1054.9 reply, could you have it done on or before the 20th of May?
Yes, Your Honor.
Okay. So May 20th will be the briefing deadline for the 1054.9. All right, and then with the, so if you're looking for at least 2 weeks for the reply, Ms. Mitchell, that your reply will be already done on the DNA before you get the responsive pleadings on the 1054.9. How much time do you contemplate you'll need for a reply on the 1054.9?
We could file our reply by June 3rd.
Okay, so reply pleadings for the defense on the DNA will be due, if you're looking for 2 weeks, that would put it May 6th. And reply pleadings for the 1054.9, you indicated June 3rd, so that's fine. Motion to seal. That is something that I think we probably can and should do before we deal with the substantive pleadings. And so I did not see a responsive pleading on the motion to seal. How much time do the people think that they would need on a responsive pleading to the motion to seal?
The only issue that we have as to the motion to seal, and this is why we have not filed something, is the documents in question that are being requested. The people have never been provided with an unredacted copy of those reports. We still do not know who these witnesses are. They're anonymous to us. So we're asking the court to order the petitioner to turn those over to us before we can actually decide one way or the other. But the people's position is we probably won't be objecting to the motion to seal based on what's alleged once we have that information.
Okay. Ms. Mitchell?
Your Honor, the identity of the witnesses whose names are redacted in the declarations that Mr. Harris is referring to have stated that they are fearful of retaliation by the Modesto Police Department if their names become known, and have asked that their names remain sealed. I would request that we perhaps have a conference in chambers to discuss this issue. It's sensitive to our ongoing investigation. There are a number of other witnesses who we have been investigating who are in a similar situation.
Okay. Well, all I'm asking for essentially is a briefing schedule for the motion to seal. And there's a procedure that's set forth in the rules of court for a motion to seal in terms of lodging a pleading with the court that is the proposed sealing and the narrowly tailored nature of it, and serving it on the opposing party. It appears that that actually hasn't been done in this case. All of the pleadings that were filed were essentially filed publicly, but with the redactions that you are proposing. So in terms of the procedure for the motion to seal, it is, I would say, somewhat unusual given the rules of court. And I anticipate that the parties will not be the only ones who want to be heard on the issue of the motion to seal, given the nature of the case. So let's set a briefing schedule. I'm not going to make any specific orders, and whether or not the motion is compliant with the rules of court and the proposed redactions are within the nature of the rules of court is something I'm going to rule on at the time of the motion, not now when I have one motion, not a response, and not all the pleadings that I anticipate that I'm going to get on it. So how much time would the people need in order to be prepared to file a response to what is in the record?
2 weeks would be fine.
Okay, that's fine. And then any reply that you may have to that, Ms. Mitchell, how much time would you need once you get the people's response?
1 week, please, Your Honor.
Okay, so 2 weeks from today is the 26th of March, so people's response will be due March 26th, close of business. And you said 1 week, Ms. Mitchell, for your reply. That would put it about April 3rd. So April 3rd for motion to seal reply. And we will need to set, let's set a hearing date on the motion to seal, and then hearing dates on the DNA and the 1054.9. The hearing date on the motion to seal can be earlier, so that'll be, we'll do that first. Proposals from counsel if we're looking at April 3rd for the close of briefing, and the court will need about a week to review on the motion to seal. So anytime after April 15th is fine. What's counsel's preference?
We can do April 16th.
April 16th is fine for us. It's fine for the court.
All right, let me just check the court schedule. Yeah, I'm free April 16th, so that's fine. April 16th, 9 a.m. motion to seal. And Ms. Mitchell, is Mr. Peterson going to want to be personally present for that or continue to appear electronically?
My understanding is that his preference is to appear electronically, but he can correct me if that is not accurate.
Okay, And let's go ahead and ask to unmute for that. Still muted. All right, Mr. Peterson, we're contemplating an April 16th hearing on the motion to seal the pleadings or parts of the pleadings in this matter. Are you going to want to appear via Zoom or in person for that?
Zoom is fine, thank you, Your Honor.
Okay, thank you. Then, for hearing dates on the DNA motion and the 1054.9, what's the party's preference in terms of hearing those together or separately?
Your Honor, we would prefer to have the DNA issue resolved as soon as possible so that if there is going to be testing ordered, we can get that started.
Okay, people?
We don't know.
Okay, that's fine. So if the briefing on the DNA motion is going to be completed by May 6th, then, and if I need a couple of weeks to read the pleadings, then we're looking at the last week of May. So any preference by counsel during the week of May 27th for the hearing on the DNA motion, and what is the time estimated necessary for that argument?
We can be available May 28th, Tuesday, May 28th.
Okay.
That is the day after Memorial Day, so I don't know if that's going to cause travel problems or any issues for the court's calendar.
I don't have any plans on Memorial Day, but if counsel do and they would prefer to go to the 29th or sometime later in the week, that's fine.
29th is fine with me.
Okay. And do we think it'll be anything more than a full day?
Don't think it should be more than a full day.
Ms. Mitchell?
Having not seen their opposition, I can't say, but I would hope not more than a day.
Okay, we'll block off a full day for it, so, and it may not take that long, but we'll be prepared if it does. May 29th at 9 a.m. for the DNA testing motion. Then the 1050, and so in terms of the DNA testing motion, Ms. Mitchell, do you know if Mr. Peterson has a preference in terms of Zoom or personal appearance?
I believe his preference is Zoom.
Is that correct, Mr. Peterson?
Yes, Your Honor.
Okay, so that'll be via Zoom. Okay, and then we'll need to schedule the 1054.9 hearing. If the briefing is going to close on that on June 3rd, then we will need, if the court needs, that is going to run into some travel plans that I have, and I'm going to need to step off the bench briefly to confirm exactly when I'm returning because it's an extensive absence in June. So let me step off the bench briefly, consult my calendar, and let you know after essentially when I'm going to be returning and when I will be available for that, and then we'll discuss dates. So we'll take a brief recess. In terms of the court's availability for the 1054.9 motion, I'm going to have to go until after July 1st. So, counsel, I'm looking at sometime during, if I'm going to be reading the pleadings after I return, I'm going to be looking at sometime during the week of July 15th.
We can be available July 15th, Your Honor.
Okay. Okay. July 15th, 9 o'clock, and in terms of your client's appearance preference, Ms. Mitchell, also Zoom or in person for that one?
I believe Zoom.
Okay. Mr. Peterson, is that correct? Still muted.
Okay. Yes, ma'am.
All right.
Yes, Your Honor.
Okay, thank you. Last housekeeping matter, the court did, to the court's department email, receive an ex parte communication from apparently some kind of a spectator. I read about one sentence of it, enough to realize it was an ex parte communication, did not read any further, and counsel have been provided, as I understand from the clerk, copies of that email. Did both counsel receive it?
Yes, Your Honor.
Yes.
Okay, thank you. And the court is not going to be reviewing any incoming email to that inbox in the future to avoid that issue recurring in the future. So people shouldn't bother to email. Okay, is there anything else either counsel needs to take up for today's date before we recess?
I have one question, Your Honor.
Yes,
We
Ms.
have
Mitchell.
received a number of inquiries from members of the press and the media asking for copies of the motions we filed. We have not provided anything to anyone in the media or the press. Apparently, they are not on the court's website, and so I'm just asking for guidance. Is there any issue with us providing the motions, or is the court planning to put them on the website so they are available?
I don't have any plans in that regard while the motion to seal is pending, at least, and I have not made any orders about what counsel may or may not do in terms of their communication with the media.
Thank you, Your Honor.
Okay.
Your Honor, if
Yes.
people can make a suggestion, one of the things that Judge DeLuca did during the trial because of the media attention and not wanting to be distracted by additional requests that would come in from the media once a motion was filed, his position was that he would take the motions filed by either side and he would hold them from being put on the website or from public filing until the other side responded, because a lot of times that resolves some of the issues or questions that may have arisen. So we would suggest that might be a possibility here as well.
The difficulty, and I think part of this, Mr. Harris, is that the court's filing procedures have changed since Judge DeLuca was the file. We don't have a lot of control over when things come in now because it's all electronic filing. So I don't actually see it until the clerk's office processes it. So while I appreciate the suggestion, it's not consistent with our mandatory filing procedure. So thank you all. Okay.
This has been a special report from True Crime Today and the Hidden Killers podcast.